Action.
Oh, I've grabbed it wrong, sorry.
Pull over.
The cops were involved in a high-speed pursuit in the big city.
In a pursuit like this, the key is to stay close, but at a safe distance. Unfortunately, policeman can't.
Constable Bell has involuntarily exited the vehicle, temporarily halting the pursuit. With Constable Bell now back in the vehicle, the pursuit can continue.
Lord, please stand before His Honor Judge Harrison. Court is now resumed. The matter of Evans and security person and licensing authority.
Please, Your Honour, I appear in this matter for the defendant, Mr. Evans.
Yes. It's Mr. Sharp.
That's correct, sir.
Is there any other appearance?
Your Honour, I saw a minute filed by, on behalf of the licensing authority that they sought to be excused.
Yes, well, I granted that.
And Your Honour,
I don't see any issue with that.
And the police, there should be, in the file, there should be notice of the affidavit of service by Mr. Evans upon the police, in accordance with the direction which Your Honour gave earlier. And I know he attempted to serve, according to the affidavit, he attempted to serve that in Takapuna, when the person refused to accept service, so eventually resorted to service by way of courier, on them. Also attempted to serve it at the main office on Constellation Drive, and the view was, well, got nothing to do with us, we're not accepting service there either. So they certainly are aware of the matter as directed by you.
Yes, right. Yes, all right, Mr. Sharp, thank you.
Additionally, you should have with you, apart from the appellant submissions, you should have a document which is entitled Documents Originating from the Licensing Authority in the appellant's possession. And Your Honour should also have a bundle of authorities on appeal that are referred to.
Yes, I have those. I'm just concerned that I might not have your actual submission.
I have
an earlier submission from you.
I've only filed one submission, sir.
Which
is saying just see, the 23rd of August 2019.
Yes. Yes, that's the one I have.
Your Honour, this matter, I'm basically just going to talk to those submissions because I take it Your Honour's read the
I've read through them, thank you.
papers. Your Honour, this matter, as you will be aware, comes before you as a result of a decision by the Private Security Personnel Licensing Authority declining Mr. Evans the license to act as a director of the company which provides security services. The nub of the appeal in this matter, Your Honour, is that my submission is firstly that the finding that was made by the authority that he is not a appropriate fit employee is not supported at all on the material that should have been before the tribunal. And secondly, that contrary to what our law provides for, which is the natural justice principles, if there was to be a reliance upon the security data, or whatever you call the register that the police have got, then the whole of that register should have been made available and not simply piecemeal parts of it. The matter essentially, sir, involves that the finding of the tribunal, therefore my submission at the end of the day is one that cannot stand and should be set aside with the finding that, subject to Mr. Evans completing whatever training he needs to do, although he's been in the industry previously with a company which unfortunately was one of the victims that were damaged quite badly by Mainzeal several years ago, is to undertake, and that he should be granted a license. And so I'm going to walk through, essentially I'm going to look at the issues of some of the annexures that are attached to his affidavit, and then we'll largely go and look at the issues surrounding the various authorities that I referred to, Your Honour, and in particular looking at this question of the failure to present the full details of that report to the tribunal, or the tribunal's failure to call for the full set and to use them, and the rather selective summary that was, or extracts that were produced by the police for presentation to the appeal authority. I would suggest that if one looks at the affidavit of Mr. Evans, and we look particularly, if one starts from annexures D, and I'm referring to an affidavit annexure which is an extract from a document of Child, Youth and Family, and in which... What's
the date of the affidavit?
I've got an undated copy, so I can't. It was filed together with the notice of the originating application.
Commencing the appeal.
Commencing the appeal, yes, sir. So I'm not quite, I don't have a dated copy, unfortunately, in my records.
Well, yes, just trying to find the annexures.
These are documents that at that stage were filed by Mr. Evans.
Yes, I understand that they tend to get spread all over the file, which well, anyway, continue, Mr. Sharp, please.
So if need be, I can leave. I've only unfortunately got one copy here, but at the end of the day, I'm quite happy to hand this copy up. I don't think I'm going to...
Well, it'll be on the file. The affidavit refers refers to annexures, but the annexures seem to have come in separately.
Oh, I see.
And I'm just trying to marry them up with the affidavit. I might have them. Was Exhibit A the decision of the
Correct, sir.
authority?
Correct, sir.
Yes, all right, I've got it now. Thank you.
Thank you, sir. Your Honour, Annexure D, as you will note from this, is a note, so-called confidential note on it. It's the bottom part of a wider series of documents. It's page 31, 721 by the looks of it, which sets out information which SIFS had concerning this gentleman, Mr. Lee. Mr. Lee is the person who was acting as it were the partner of Mr. Evans's former wife, and who was acting as it were as the in inverted commas stepfather to the two children, and they were residing with him and Mr. Evans's former wife at Mr. Lee's residence. The interesting thing about Mr. Lee is that it was well known to SIFS that they were dealing with a person who, as Your Honour will notice from the alerts at the bottom of that document, is one who uses and carries firearms. Lee was convicted in 2010 for being in possession of an AK-47 and a .22 rifle with a silencer. Your Honour will be well aware that the AK-47 is an assault rifle, an automatic assault rifle. It's not a toy, and it's the weapon favoured by most sort of groups which have engaged in conflicts with backing of particularly Russia and the People's Republic of China. In addition, Your Honours will notice that these were located in his house along with a quantity of methamphetamine. Treat with caution. There's references then further to drug manufacturer. There's issues of located in a vehicle and a storage unit in Hillside Road, Glenfield. And then at the bottom is this note: intelligence information not for broadcast, confirm out of hearing of subject prior to radio advice to staff. Do not advise subject of this alert. The person is of interest to OCADS, Asian Organised Crime Unit. Your Honour, apart from the end result for Mr. Lee, what we're dealing with here is a person who quite clearly is someone who has not had an issue in the past of using or carrying a firearm, somebody who is actively involved in the manufacture and distribution of methamphetamine, and a person whom surprisingly SIFS, wherever I don't know if it was the Lucy Liu, the social worker at Otho, or who it was, and I noticed that it says at the top this was created by Lucy Liu on the 18th of November, that SIFS, with the greatest of respect, in my submission, are really living in cloud cuckoo land when a decision is made by them that this situation poses no threat to the children. But what is worse, Your Honour, is that you will notice from the affidavit, this information was passed on to SIFS by the police, who didn't want the bust that they were planning of this gentleman disturbed by the children being removed. And so the police were quite happy to leave these kids, never mind the overriding obligations of the safety of the child in the Children's Act, quite happy to leave these kids in this environment so that the bust didn't get disturbed by the process. And Your Honour will have noticed that there is a comments by His Honour Judge Richard Erica when it came to the sentencing of these people, and that appears at Annexure F in the bundle, Annexure F to the affidavit, where His Honour goes into details about the scale of the operation and the approach to the sentencing for the gentleman in question, Mr. Lee, who is sentenced to a period of imprisonment which Judge Erica puts at 10 years with a minimum 5 to be served, and describes it quite correctly as a serious, at the high end of the scale that we're talking about in this particular matter. So that appears at page 20, the sentence summary appears at page 25 of that particular document, where Judge Erica supplied, on the charge of supplying methamphetamine, possession of methamphetamine for supply and manufacturing of methamphetamine, who is sentenced to 10 years and 8 months imprisonment on each, with a minimum period of imprisonment of 5 years. On the charge of possession of materials, possession of equipment, possession of precursors, the sentence will be 2.5 years on each, all to be served concurrently. I want to submit, sir, that given this, and given the fact that quite clearly Mr. Lee was not averse to trying intimidatory tactics, and I take you here to Annexure E in the affidavit of Mr. Evans, where Mr. Evans complains to the police. And interestingly enough, this document doesn't seem to feature as part of the material which is ever put up by the police in their complaint or their grounds to the licensing authority, that Mr. Evans makes a statement to the police in which he says that on the 6th of July 2014, he sees Mr. Lee parked outside his address of flat 281 White Power Road, Birkenhead. And there are 4 other Asian males in the vehicle. There's no doubt in his mind that it was Mr. Lee, having met him on numerous occasions, having met him face to face, including at his home, Mr. Evans's home, when children were dropped off, having met him at the bottom outside the Constellation Drive police station, and at North Shore Court, where he's appeared every month in the past few months. And he describes how Mr. Lee was there with 3 other people in total, just parked watching Mr. Evans's place. This is a situation which I'm going to submit, and I can also point out so that Judge Bidwell in the family court matter had very strong criticism of both the police and SIFs for the way that they behaved. And the fact that their conduct was a major concern to Her Honour in the particular matter. And really, that is the kernel of Mr. Evans's beef, if I can put it as such, with the police and with SIFs. That there was this absolute abrogation of their obligations in the matter, and that there was no attempt to actually respond to his concerns, as I'd submit any responsible parent would have. And I can only speak from a position as a parent and a grandparent in these matters, that having kids living in that environment, having kids being exposed to the potential of dealers and runners coming in to buy methamphetamine, arms in the place, this would to any parent be a major cause of concern. And there's no question that Mr. Evans feels deeply annoyed and angered with the police for what their failures were in this matter. And I want to submit that really, sir, if we go to the document, which is the police intelligence data document, and that is contained, so I put that separately in the documents, the bundle of documents originating from the licensing authority or received by it. And that appears at page 7 of that particular small bundle and following. Now, interesting comments about that particular document, Your Honour, are that the person who compiles this summary, and it is, or extract, it's not a summary, it's an extract that's been made. And the person who has done this is the gentleman who the notice of application was served on, the police officer attempted to be served on, Constable Michael Wilson, Senior Constable Michael Wilson. And the interesting thing about this, Your Honour, is that if we look at page 7, one sees immediately that not 1, 2, 3, 4, 5, 6 lines down, it is an incomplete extract of the register. It reads, not all of the occurrences are relevant to this application, with some concerning official information request or police conduct / allegation complaints. I've omitted those occurrences from the list below. The problem I have with that, Your Honour, is that instead of providing all the information that the police want to rely on, this particular police officer has taken it upon himself to decide what he believes the licensing authority should hear or see or not. And even more disturbing is the fact that although in his one correspondence he says lower down, should the complete noting be required, I will need sufficient time to properly redact sensitive information. 2 issues arise from that. One, it's surprising that the tribunal never asked for the whole record to come before it, given that the tribunal has an overriding Section 27 BORA, New Zealand Bill of Rights, obligation to act here in natural justice principles. But also, as I submit to you presently, sir, if you're going to make discovery of a document as opposed to Official Information Act provisions or Privacy Act provisions where there are specific provisions in terms of which information can be withheld, in disclosure, there is no withholding information because you feel that this must be redacted. We deal with, as Your Honour will know well, we deal regularly with information that comes up in discovery processes, which are confidential, be it for business commercial reasons or sensitive personal information about people. And the way we deal with that normally is that counsel give undertakings as to confidentiality, as to how to be dealt with, or the parties make undertakings that they will retain the information, make no copies, and at the end of the matter destroy the documents in their possession. So there's a way that it can be dealt with. The interesting thing about this set of papers is that when one goes through it, it is almost a non-stop litany of issues about the kids and the way they haven't been removed from the environment and how the situation has been dealt with. The licensing authority in its determination talks about Mr. Evans showing a lack of cooperation with other governmental institutions or structures. Well, with great respect, I struggle to find any basis for that if this was the material upon which the licensing authority relied. If there was other material that was relied, well, we certainly have never been given that information to deal with. So, at the heart of this issue is a man who is unashamedly, and he admits it in his affidavit, cross with the police, and I'd submit understandably so, about the way they dealt with this issue of his children and Mr. Lee and his methamphetamine enterprise that he ran from their home. There is no indication in this matter that Mr. Evans has a beef with the police about him attempting to catch people who murder, or people who defraud banks, or people who have terrorized people in their homes, home invasion. There's no indication of that whatsoever. The whole process relates to this particular matter. And I want to submit to you, sir, that there are probably in New Zealand, and I've obviously got no stats about it, but just when I talk to my colleagues who work in this area, I am advised that there are numerous people who are disgruntled with events when it comes to family matters and children and custody and where the kids are kept, etc. So it's not something abnormal that has occurred in these circumstances. So, Your Honour, that's the background against which the authority then, or the licensing authority, now looks at the material that they have. And so, quite frankly, I want to submit that if Your Honour has a look, for instance, at the actual decision, which is in the of the authority, this is in the bundle that separate bundle I prepared. It's also in Lecture A, and in the separate bundle it appears on page 2, paragraph 11. The statement is made by, in paragraph 10, that Mr. Evans shows little insight into how his actions and words will be interpreted by others. When confronted with a different interpretation from what he says he intended, rather than accepting his actions or words may be inappropriate, he at times goes on the attack by criticising the person who allegedly misinterpreted his actions, and in some cases filing complaints against him. Well, let me just stop there and say the complaint, for instance, against the psychologist was perfectly valid. It was upheld by the psychologist board as her acting without informed consent. Surprisingly, she was told to have some re-education, as it were. In days gone by, sir, when you acted in that manner, you normally ended up, I'm talking about 20 years ago, which probably dates a bit, you ended up with being suspended for a period of time. Now we just re-educate these people. But the fact of the matter is that this wasn't as if Mr. Evans sucked this out of his thumb. It was a justified complaint. It was found to be justified. He goes on, in addition, rather than accepting criticism, he justifies his actions. Examples can list in phone call to Ramatamiki, which shut down the Takapuna office, and his email to court, which wasn't probably the bravest thing to do, and his email to the court-appointed child psychologist. The problem I have with this, sir, is the question is that when we look at section 53, which this has all been presented under, and to go to the bundle of authorities that Your Honour has in right at the end of it, we've got produced an extract of the section, relevant section. That's at page 122 in that bundle, sir. The question is essentially what we have to determine, or what the licensing authority had to determine, was whether Mr. Evans would be a, quote, responsible employee. Now, with great respect to the person who sat in the tribunal, how those incidents referred to in paragraph 10 lead one to a conclusion that the person is not a responsible employee, quite frankly, I struggle to wrap my head around. And I say that as counsel who has quite a large practice in employment areas, where in employment, Your Honour, there are all sorts of employees. There's the employee who will question what is being said and challenge, and they have a right to do that. There's the employee who will meekly toe the line and just follow instructions, unquestionably, unhesitantly. There's the employee who will do the job but mumble about it. If we had to peg and punish employees because of how they respond to circumstances, particularly matters outside the environment of their employment, we would be really not only would we be so busy that we wouldn't know what to do, but employers would be facing claims of considerable amount for the harm caused by the actions. It is just totally illogical, the finding that is arrived at. It is with respect unsupported. And then in paragraph 11, he has a history of being obstructive and uncooperative in his dealings with the police and some government organisations. As I've said to Your Honour before, what government organisations are we talking about here? The only ones that we can see that he's got a cause or really a gripe against and an issue with is SIFs, as it was called then, and the police for the way they dealt with it. And he says, says the finding, both agencies need to address the culture of criminality and criminal negligence within their own rank, rather than criticise him and manufacture evidence. But that's his opinion on what happened in the circumstances. Whether one agrees with that or not, that's not really the issue. And that certainly doesn't affect whether a person is a suitable employee or not. What it has done, what this whole thing has done, and what I submit is probably part of the reason why we, A, don't have the rest of the document, and B, why the police haven't fronted up to the hearing today, is that because of these things, Mr. Evans has got involved in social justice issues as set out in his affidavit, and some of those would be matters which probably irritate the police even more. The fact that maybe there's a social justice media site, there's a radio site, there have been silent protests of these matters. And whether or not one agrees with that, the fact of the matter is we are a democracy and we are a country that prides ourselves on the person's right to express different political and social views. And that is a right that is so fundamental and so critical in times of growing legislation which comes along and encroaches on that. And for instance, the Search and Surveillance Act is one of those examples. And so the bulwark between the individual and the might of that type of power is this court that stands between the two and creates the barrier and the protection that exists here. So, Your Honour, if Mr. Evans must be penalised because of what his political social views, well, whether he thinks that the previous Minister of Health was a bit of a wally or not, it's not relevant to the question of his employment, and in my submission whether he should get a licence. There's nothing in the material that this authority has which can even remotely indicate that Mr. Evans, if there was some matter of security that was involved, and the police indicated that we need to draw a cordon around this area of 150 metres to secure it so that people can't get in, that Mr. Evans would not comply with such a provision. There's nothing to suggest that whatsoever. So on the facts, Your Honour, that we have, I'm submitting that there's factually, in terms, first of all, with the rapid reasoning of the licensing authority, there's serious non sequiturs that take place here. What we don't require of people, and God forbid we ever get to that stage, is that people should become toady followers of simple instructions in employment and should not speak up when they disagree with something. That would be an appalling situation for us to reach if we ever got to it. So, the facts, having looked at the facts, Your Honour, I want to just briefly take Your Honour through some of the issues that appear from the point of view of, firstly, the question of us looking at the law of the subject and what the courts have had to say about it, and support for my proposition that I've raised, that this failure to come up with the documentation is a fatal matter, which in itself justifies the discipline it sets out. And as a starting point, I've used an extract by Dr. Colin Aikman, which appeared in the Victoria University of Wellington Law Review. And Dr. Aitken was a member of the New Zealand delegation which presented New Zealand's case at the Paris meeting of the UN General Assembly. And we're talking about particularly the importance that our courts attach to looking closely at protecting individuals' rights to work and due process when that issue of the right to work comes under question and attack. And this appears in the bundle, sir, at just the index. At page 114 to 119, and particularly the bit that I'm looking at here is at page 116 in the bundle. And it appears that this quotation that or the extract that I have put into my submissions actually comes out of the section under the heading Economic and Social Rights. And so just read from under the heading of Economic and Social Rights. A persistent area of disagreement of human rights standards has been whether economic, social and cultural interests should have the same status as traditional liberal values such as life, liberty and freedom of speech. Despite Franklin Roosevelt's inclusion of freedom from want in his four freedoms, the Western Allies as a group show little enthusiasm for the inclusion of social and economic rights in the Declaration. On the other hand, the Eastern Bloc argued not only for their inclusion, but also that the responsibility of the state for their promotion be recognised. On this issue, the Third Committee and the Assembly made relatively few changes to the draft declaration that had been submitted by the Commission of Human Rights. The declaration proclaims economic and social rights, but responsibility for their implementation is placed on states only, in the very general terms provided for in Article 22 of the Declaration. In the absence of Mrs. Newlands, I was given the opportunity to state the New Zealand position on this issue before the General Assembly. And that's as follows. My delegation attaches equal importance to all the articles. At the same time, we regard with particular satisfaction the place which is given in the Declaration to social and economic rights. Experience in New Zealand has taught us that the assertion of the right of personal freedom is incomplete unless it is related to the social and economic rights of the common man. There can be no difference of opinion as to the tyranny of privation and want. There is no dictator more terrible than hunger, as we have found in New Zealand, that only with social security in its widest sense can the individual reach his full stature. Therefore, it can be understood why we emphasize the right to work, the right to a standard of living adequate for health and well-being, and the right to security in the event of unemployment, sickness, widowhood, and old age. Also, the fact that the common man is a social being requires that he should have the right to education, the right to rest and leisure, and the right to freely participate in the cultural life of the community. These social and economic rights can give the individual the normal conditions of life which make for a larger freedom. And in New Zealand, we accept that it is the function of the government to promote their realisation. I interestingly, on rereading this, noted the statement made by Mrs. Eleanor Roosevelt that my government has made it clear in the course of development of the Declaration that it doesn't consider that economic and social and cultural rights imply an obligation to ensure the enjoyment of these rights. And I was just thinking about what's happening in the United States at the moment, and probably there was a bit of deja vu when one looks at that and what's happening there at the moment now. So the right to work is something which our courts have and our society has, Your Honour, guarded and valued very, very highly, because the effects of, in actual fact, losing one's work and not being able to work, as has happened to Mr. Evans here, as a result of these decisions, and the result, I'd submit, is because of the police's selective data and the failure of the tribunal to actually inquire as to what the real reasons are pretty serious. The first point is that the privacy, the issue of getting these documentations is that even the Privacy Commissioner has in recent times come, or actually as early as 2010, indicated that these national intelligence data are documents which should be produced. And there's, for instance, in the bundle, there's a case note at page 120 and 121 going back to 2010, in which the complainant made a request for the personal information they held about him. And this incident related to immigration charges that had been laid. And again, there the police tried all sorts of, let's try and use the technicalities of was it not perhaps readily retrievable, and eventually they had to concede it could be easily retrievable, and the Privacy Commission directed them that they should produce it. I also came across one subsequently, which I can't find in the database of the Privacy Commissioner, but I found an extract. That's why I haven't included this in the actual bundle of cases. An extract reported by Stuff, the newspaper group, which, if I can just hand that up to you through your registrar, sir. Copy of that. This is a matter reported in April this year, and which is exactly this type of data that we're talking about here. And I mention this because you will also notice in the affidavit of Mr. Evans, there is a document, I think it's in Lecture B, you see where he actually has applied to the police to get his information, and he's got nowhere with it at all. And in this particular matter, there was a gentleman, Mr. Salah, who asked for his information, and the police said no, it would disclose how the police do certain aspects of its job. And this was a gentleman where he was concerned because the police had incorrect information about him, possibly, and pointed out that having an incorrect NIA alert on his file might put him in a dangerous position with the police, responding disproportionately if they came into contact with him. I would say probably a wider concern was that if there was any request ever made about him to police from prospective employer or something, the potential for misinformation was pretty high. And this, he was ordered, he asked for his information. 5 months later, he complained, which found 5 months later, the Privacy Commissioner found that he was entitled to all the alerts. And then still, the police did nothing about it. They didn't comply. Because now the Privacy Act has been amended, or is in the process of being amended, which will enable the Privacy Commissioner to compel people to disclose information. But in relation to, for instance, the amendments that have come out in the Australian piece of legislation where failure to comply with orders of the Privacy Commissioner, where fines running into millions of dollars, we limited to $10,000 in the amendment as a fine that can be imposed. And only after the newspaper gets involved, Your Honour will notice that in response to questions on Monday afternoon, police emailed Stuff a copy of Salah's alert. So they don't send the alert to him, the police send it to the newspaper, to Stuff. And then a statement arrived shortly afterwards from a police spokesman saying that police are aware of the Privacy Commissioner's advice and the information regarding this individual's alerts will be released to him. Unsurprisingly, the New Zealand Police Conduct Association President Shannon Parker said that she was astounded that it had been released to the reporter when they'd been refusing for 5 months to give it to the person in question. So those particularly, the information on these national intelligence are not sacrosanct, as it would seem to be that the police believe that some sort of MI5 type of material that you just hold. It is, people are entitled to know what the police are holding about them. So, if we look at some of the authorities then that have been referred to, Your Honour, probably the starting point that I would start with is that the proposition that proper disclosure of material both adverse and supportive is of high importance, and particularly in New Zealand, where the courts have required due and full disclosure of reports relied on by people making decisions. And there's an early decision of that, which occurred in the Mockford decision and the Mill Court, which appears at page 1 of the Bundle of Authorities. Now, basically what happened there was a similar sort of parallel type situation, where Mr. Watford was suddenly, there was a decision of the Mill Court that he was no longer to be a distributor of the court, and they revoked his license to act as a distributor. And that matter then came before the court. And the interesting things that take place in that particular matter are that the court, the council all agreed that in this particular matter, and this obviously precedes the Bill of Rights Act, council on page 7 agreed that the board and its review committee were bound to proceed in accord with the principles of natural justice, particularly when its decisions could have the drastic effect of depriving the plaintiff of his livelihood. And that's a theme that the courts do come back to often. The question that we're dealing with potential to deprive a person of his livelihood. There's a very close scrutiny of what occurred in the process to whether natural justice was complied with. And immediately following that quotation, Your Honour will notice that Mr. Don Matheson, Don was appearing there, had argued that the breaches of natural justice had occurred inter alia. And firstly, the plaintiff was denied adequate opportunity of knowing the case he had to meet, of answering it and of putting his own, and secondly, unfairly deprived of an adjournment to enable him to consider the material divulged at the hearing for the first time and seek legal advice. And those two grounds were upheld completely by the court. And the court interestingly rejected at page 9 of the bundle the submission which had been made by Mr. Mackenzie that because it was a discretion, there was no need to go along and apply principles of natural justice. And in that particular matter, the learned judge at page 12 referred to comment of Justice McGarry in the matter of Leary and National Union of Vehicle Laws, when he said that if the rules of the law combine to give the member the right to a fair trial and the right of appeal, why should he be told that he ought to be satisfied with an unjust trial and a fair appeal? Even if the appeal is treated as a hearing de novo, the member is being stripped of his right to appeal to another body from the effective decision to expel him. I cannot think that natural justice is satisfied by a process whereby an unfair trial, although not resulting in a valid expulsion, will nevertheless have the effect of depriving the member of his right of appeal when a valid decision to expel him is subsequently made. Such a deprivation would be a powerful result to be achieved by what in law is a mere nullity, and it is no mere triviality that might be justified on the grounds that natural justice does not mean perfect justice. As a general rule, at all events, I hold that a failure of natural justice in the trial body cannot be cured by a sufficiency of natural justice in an appellate body. Now, put that, draw attention to that because there are some cases in Australia, and Australia, of course, doesn't have a Section 27 Bill of Rights provision which applies to all tribunals, that in cases where you have, some of the cases, there's a bit of a dispute, that if you have the right of an appeal to a second level, natural justice doesn't have to apply necessarily in the first level. In New Zealand, our situation is somewhat different, and we have a different approach to that. And one of the authorities that Your Honour will see in the bundle is the one which is, I'm not going to go to, just mention it, number 9, page 123, I beg your pardon, number 5, at page 91, which is the combined beneficiaries union matter, which was the Court of Appeal decision, which simply indicated that the Bill of Rights provisions, section 27, applies to all breaches of natural justice. And so New Zealand, we do have a somewhat different situation. The second matter that I would look at, sir, is the Daganayasi decision, which, picking it up essentially at page 26 of the bundle. This is a decision by Lord Cook, or Justice Cook as he was at that time, in which His Honour indicated that really what was an issue here, that the appellant should have a fair opportunity, I'm reading from line 9 onwards, the appellant should have a fair opportunity of correcting or contradicting any relevant statement prejudicial to his or her view. Probably the same should apply if the person designated to make inquiries or report happened to be an officer of the department rather than an outsider. This wasn't, you're not probably familiar with this was a situation of a lady who was from Fiji, with a child had a medical issue. There was a conflict, there was 2 reports, one report which indicated that the child would not get sufficient appropriate medical treatment in Fiji, was not put before the, provided to her, and the Court of Appeal upheld in the circumstances the deportation order could no longer stand in the matter. And coming to that particular conclusion, His Honour Justice Cook looked at what he described in line 25 as 4 major decisions, and particularly the one I just want to draw attention to very briefly appears at page 27 of the bundle, at line 12, which is the New Zealand case decided by the Privy Council, Jeffs and New Zealand Dairy Board, 1967, appeal cases in the Privy Council. And the important thing is, as Justice Cook in that matter indicates, the Lordship's recognition that the Board might satisfy natural justice by arranging the person to receive evidence and submissions and fully inform the Board thereof, or in some circumstances by having an accurate summary of the evidence and the submissions. The problem we have in this matter is we don't even have an accurate summary because there's quite clearly material has not been put that in favour of Mr. Evans. And in actual fact, it's been a selective process that's been conducted by the particular police officer involved.
There was no hearing, was there? Before the authority?
No, it was all on paper, sir.
I'm stated that a man can lose his job, his position, without even a hearing taking place.
It's one of these pieces of legislation that one, how do I put this diplomatically, you look at and you go, really? But there's several of them that are like that today, so that in actual fact people don't have the right to an oral hearing. There's, my memory certainly correct, under the police surveillance provisions, you have the right to put submissions forward, but you don't necessarily have a right to an oral hearing.
It's extraordinary.
Your Honour, the next case that, similar vein, but in actual fact one that has got a definite employment line to it, is the Philpott decision. And seem to be having a technical issue with the system here, but anyway. Philpott is at 33 and following in the bundle. And this is a decision by His Honour Justice Ronald Young. Mr. Philpott, the interesting thing about Philpott, sir, is that Mr. Philpott, again a deportation matter, but the interesting thing about Philpott is, this goes back some years now, 2005, Mr. Philpott was part of a group who conspired to kidnap the party and hold the party to ransom in exchange for, obviously, a payment. And then Mr. Philpott kind of got cold feet halfway through and was actually convicted of really just being an accessory more than anything else. When it came to the question of looking at the question of the immigration issue, Mr. Philpott's wife had rights of, was a New Zealand citizen, she had also rights of residence in the UK, but the Immigration Department felt that based on the severity of the offending, they couldn't agree to Mr. Philpott remaining in New Zealand. Justice Young found that the proceedings in actual fact had serious issues in it, and he found that for our purposes, that the natural justice had been not adhered to, and that what had was a situation where an important letter which was favourable to Mr. Philpott was simply not at all produced at all. And so there was no information whatsoever put before them, before the minister was, regarding this particular aspect. And so Justice, paragraph 53 of the judgment at page 51 in the bundle, is quite relevant, because here Justice Ronald Young says the following: where a decision maker receives information that is relevant in its decision making and which it intends to take into account, but which the parties may not be in possession of, then as a matter of natural justice, it should provide the information to the parties and provide them with an opportunity to comment on the full information. This is basic procedural fairness, identified as fundamental to proper process by Lord Reed, in Wiseman and another, and Baldwin and others, and that's a House of Lords decision. He was very critical of this, and again in this particular matter, Justice Young pointed out the effects that you have, the disastrous effects that can arise with a person, employment issues, and basic human concerns that were not addressed and not looked at by them, and were aggravated and caused by the breach that occurred in the circumstances. The Court of Appeal's decision, the decision of Secretary for Justice and Symes, is one. This involved Ms. Symes, who was a barrister, who was a legal aid approved provider, and there was a decision that basically concerns were raised by the LSA as to performance. The relationship between her and the LSA went downhill rapidly, and they appointed a special audit of her work. And basically what happened in this matter, they did not provide her with any details of some of the decisions that they relied upon in coming to the conclusion that her authority as a legal aid provider should be withdrawn. And the critical thing in this particular matter is that the Court of Appeal indicates very clearly that the purpose of giving people information, of both information that is against them and information that is in their favour, is that what it does is that it allows the party to use the information that's in their favour and to actually comment quite on the information that is against them. And that was pointed out by the court just find my reference for that one. That paragraph, I think it was 80. If I can just check that.
Paragraph 80, I think.
Yes, I think it's 80, sir. Oh, I seem to be going the wrong way, that's what we're finding. Yes, from 79 onwards, sir. So we are unable to accept the submission made on behalf of the LSA. It's abundantly clear that the review panel's reference to other decisions in relation to other providers was a relevant and material consideration in the review panel's decision. It was, at the very least, a matter the review panel considered supporting its decision to cancel the Symes listings. The submission that the cases did not provide relevant or helpful guidance is not sustainable. The review panel itself plainly considered the other decisions were relevant and helpful. It does not matter whether the circumstances of the other cases might be viewed more seriously or not. Natural justice requires the disclosure of material the decision maker intends to take into account, so that the party or parties affected have the opportunity of rebutting material that they may consider adverse and taking advantage of matters that may be considered favourable to that party. The interesting thing in this matter is there's absolutely nothing that's revealed to the tribunal and nothing called for by the tribunal which relates to anything favourable. It's all, these are the negatives that you need to be looking at. And so this is a major, again, a major breach of the issues here of natural justice that occurred in this particular matter. So, Your Honour, at the end of the day, therefore, my submission is that when one looks, there's just one further point, interesting enough, with regard to the police argument of wanting to redact things. I came across earlier this week, I went to the decision that I referred to about Wade, and I called for that decision. This is an Australian decision, if I can just hand this up to you, sir. And what's interesting about this particular decision is that it very clearly states that if your information that you've got is so confidential that you don't want to disclose it, then in actual fact, you can't use it. And what happened with this particular matter, this is the Canterbury Building Society in Baker, Administrative Law Division in the New South Wales. This was a matter where a building society was the subject of an inquiry by the registrar into the working and financial conditions of the building society. And at page 279, halfway between paragraph E and F, the drama relating to this little matter of the report, again the registrar's office didn't want to disclose it. So the judge says, Justice Shepherd says, there's one matter which is in the realm of particulars in respect of which I do think the rules of natural justice are not being observed. Mr. Lusted has, as I've mentioned, reported upon the affairs of the society pursuant to section 1189. The delegate has his report and proposes to use it to assist him in examining the witnesses to be called. He has refused to make the report available to the society or its counsel. It seems to me, from what he has said generally in the transcript, which I've read, that he intends to make use of it and to weigh out what Mr. Lusted has said against what witnesses may say. If the inquiry proceeds in that way, the society will be denied access not only to information but also to findings which may adversely affect it in the minds of the delegate and the registrar. Yet it will have no opportunity really of correcting what is contained in the report. Counsel for the defendants impressed upon me the need for the preservation of the confidentiality of such a report and referred to the fact that such a report might be made into the affairs of a building society far larger than the plaintiff here. The making available of that report might lead to it being leaked, to use a current expression, to the press or to members of the public. It might be misinterpreted, or its effect might be misunderstood, with the result that the funds and thus the liquidity of the society might be placed in jeopardy to the detriment of the members and creditors. And then picking up between B and C. Nevertheless, I appreciate the force of the considerations which have been put and the anxiety of the registrar and the minister with the public interest in mind to keep information of this kind confidential. But it is my conclusion that the rules of natural justice do apply to the proceedings, and I do not see how effect can be given to them if material is going to be adverted to by the person conducting the inquiry, of which the person who may be affected by the outcome of it is kept ignorant. Problems of confidentiality of documents arise from time to time in court. Sometimes arrangements are made whereby documents are produced only to counsel or to counsel and solicitors. On other occasions, documents may be produced to parties in return for an undertaking to the court that their contents will not be divulged. The registrar and his delegate are not in the same position as a court to obtain undertakings of this kind, and I'm afraid that the report must be made available without restrictions. On the bottom, between E and F, my conclusion is that the rules of the natural justice applying to the proceeding, a copy of the inspector's report ought to be made available to the plaintiff. That should be done before the inquiry proceeds further. So there's really this whole story about, oh, if you want further information, I can give it to you, but you need to give me some time because I need to redact it. Doesn't wash in terms of proceedings like that. Your Honour, my submission therefore is taking the matter as a whole. My submission is that the decision made cannot stand, and my submission is that the appeal of Mr. Evans should be upheld and that Mr. Evans should be granted a licence, subject to him doing, there's some training that he's got to do. The Act provides that he has 3 months to do it in after he starts working, so I would imagine the proper way to do it is that he's granted licence subject to him completing his such further training as required by him within a period of 3 months of commencing. Your Honour, there's no issue as to costs here. I'm acting pro bono in the matter. However, I would ask Your Honour to consider that possibly disbursements that have been incurred, for instance in research material and the like, those disbursements could be forthcoming. Of course, I don't quite know who would pay them in this matter because
well, effectively it's the police who are the objectors before the authority, and now responded to this appeal and they haven't appeared.
Your Honour, those are my submissions. If there are any other aspects arising from the matter that I can assist Your Honour with, I'm more than happy to give it a shot.
Well, just assist me a little. As I understand it, Mr. Evans is a company director.
He was appointed as a director of the company. I don't know if he's still nominally a director, sir.
No, I had to resign because I didn't have a license. So the future of that business has all been stunted because.
Well, I understand that years ago, under the Ford statute, I was the registrar of private investigators and security guards. So I've looked at a lot of these, but there were two separate classes. You had the employees who held a certificate of approval, and the standard they had to meet was considerably lower than for a licensee. And generally, if my memory serves me correct, directors of companies who had the day-to-day control of the companies had to meet the highest standard. Do you know if that's continued in this current legislation?
I can't answer that off the top of my head, sir.
Oh, well, I'll have a look at that. But the overlying criteria used to be that the individual was a fit and proper person. And fit and proper person entailed looking at, say, a criminal history. Now, as I understand it, there are one or two minor things in Mr. Evans' history, but nothing that seems to be of any relevance to working in the security industry.
Correct, sir.
And then fit and proper also turns upon whether the individual actually has the capability of doing the job, whatever it might be. I mean, it's no good appointing someone to a position if they're going to be completely hopeless at it. I mean, well, the public has the right to rely upon the efficacy of the certificate or the license, whatever it might be, as a tacit recommendation or assurance anyway that the holder is actually able to do the job that the members of the public have heard it before. And so that's a relevant consideration, but I don't read into this matter any criticism of those aspects of Mr. Evans' qualifications.
No, sir. It seems to be totally based on what was conveyed in that police document.
Which, as you've been pointing out, relates almost, solely to the question of custody and access to these children and how these various agencies have conducted themselves. And as I understand it, there's no evidence from the police of any occasion on which Mr. Evans, acting as a security guard, failed to either pass information to the police or cooperate with them or anything of that nature.
That's really interesting, sir, because if they'd done proper investigations, they would have been able to establish that he had this business deal previously, which went through, well, there were two things that happened. There was some litigation involving a deal with one of the energy companies which they reneged on, and then there was the hit, and a major hit they took with Mainzeal going to the wall and just basically one morning getting a phone call. In actual fact, that's where the motor vehicle conviction, where he drove, he got this call from the site, his workers saying, you better get here because they're shutting us down, they want to take our tools, etc. And he had a license suspended, but he got his car to go and sort that out. And the judge in this court here, when he got those circumstances, basically just charged him without conviction. If they'd just done a bit of investigation, and my assessment of this matter is they're so fixated with the fact that he's criticised them as the police that it's become almost a cause célèbre with them, and everything else just paled into, it's just by the side. This is the thing. Evans is after us, and Evans wants to get. And just from the bar stuff, I'm told that my client was walking on Manly Beach the other day, and met a policeman who introduced himself as Steve Evans. Oh, you Steve Evans. It's kind of almost like this is, and certainly it probably hasn't been helped by the fact that, when I say helped by the fact, I don't mean that in a derogatory way, Mr. Evans is involved in a more public advocacy of people's rights in the courts now, probably in family court matters, and that's also probably grating, if I may use that word, the police in the circumstances. But that's, as I've indicated, his right to do.
Yes, right. All right, well, thank you, Mr. Sharp. I'll reserve my decision. I want to look at this statute again. I'm not familiar with that one. I knew the earlier one just about off by heart, but things have changed quite a bit since then, so I just want to have a look at that. And as far as I'm aware, this is the first appeal under that legislation.
As far as I'm aware, so I haven't been able to find anything.
A degree of care is called for, so I'll let you have it just as soon as I can.
As you will, please.
Thank you.
I hope that this episode has provided just some brief insight into how we work.
So in a nutshell, we won't go into the situation, we don't have time, but we will assist with the rolling cone off. Our job is pretty much a safety role to land assistance. Oh, Jesus Christ!
But then, drama.
This is Constable Marty Hernandez. He's involuntarily entered the vehicle through the windshield while he was doing a rolling cone off. This is not an ideal situation, but it is a new situation we have here. And
You alright, Hernandez? You alright?
to be honest, he should have been wearing the vest.
Just hit subscribe if you would like to make following easier for you. I look forward to catching up with you next time. All the best.